ground 4 for good order. I will deal with the other grounds as I carry on with these submissions. The governor is accused of dismissing Dr. Ntoiti, Paul Mwaki, Kenneth Kimathi Mbae, and Joseph Kithure in usurpation of the powers of appointing authorities. The mover of the motion was taken through this ground as against what was count 4, paragraph 16 of the motion that was before this House in November last year, my apologies, in November last year. She confirmed that there has been no new action on the part of the county government in respect of these officials. She confirmed that what she was complaining about here is the same action that informed the previous allegation in the previous impeachment motion. While at it, and so that I don't revisit this question, I'll also deal with count number 3, paragraph 3 of the present motion, where the governor is accused of employing a bloated workforce of at least 111 personal staff in her office. The mover of this motion came here and she conceded that this was the same allegation in count number 4, paragraph G of the motion that this Senate dealt with in November last year. The question I want this Senate to grapple with is this, and this is a question of principle. Is it permissible for this Senate to be called upon to re-debate the same fact over which it debated and acquitted the governor? Is it permissible in law? Is it permissible in good sense to re-debate and make a decision on it? Are these grounds you are going to vote for, or are these grounds in your private discussion and deliberation are going to move that must be struck out first before you consider the residue of the motion? That's something that I invite this Senate to grapple with so that it guides future processes of this nature. I'm making out an argument that the governor invites this Senate to take a position on allegations that have been debated here in previous impeachment motions and in respect of which the governor has been cleared of the same. May I draw the attention of this Senate to the fact that the move of this motion confirmed that in respect of the claim of employment of a bloated workforce, the same list of employees in the same order that was presented here in November last year is the same list of employees in the same order that she has presented here today, and sought that this Senate reviews its previous decision and enters a different decision from the one it entered last year. The second set of matters that I want to deal with is matters that are pending active litigation in court as we stand here today. What I'll describe as matters that are sub judice. Count number 1, paragraph 1 of the impeachment motion alleges that the governor illegally revoked the appointment of CPA Virginia Kawira Miriti as CEO of the Meru County Public Service Board. Distinguished senators, it is not in dispute that this matter is pending active litigation as Meru Employment and Labor Relations Court, case number E002 of 2024, Virginia Kawira Miriti versus the governor, Meru County. The governor invites this court to consider as a matter of principle what is its policy on matters sub judice. what is the policy of this Senate on matters that are pending active litigation before other competent institutions of dispute resolution. Evidence of the pendency of that case has, of course, been supplied in volume number 2 of the governor's documents at page number 14. Another matter that the governor wants you to apply the same mind on, that is matters that are actively pending in court, is what I referred to earlier as count number 1, paragraph 4, on the alleged illegal dismissal of Dr. Ntoiti, Paul Mwaki, Kenneth Mbae, Joseph Kithure Mberia. In addition to the fact that this is a matter that this Senate has already applied its own mind upon and made a decision on, it is not in dispute that this matter has been and continues to be in active litigation in our court. This matter went into court as Meru Employment and Labor Relations Petition number 1 of 2022 and is now pending an appeal. Evidence of the pendency of that appeal process is at volume number 7, at page number 71, volume 1B of the governor's documents. Again, distinguished senators, with tremendous humility, I invite this House to take this as a question of principle. What is the policy, the legal policy of this Senate on matters that are actively pending in our courts, such as ground number 1, paragraph 4, count number 1 of this impeachment motion? If you look at ground number 2, paragraph 6, and ground number 3, paragraph 11 of the impeachment motion, that motion, just for good order, is in the County Assembly's documents, volume 1. This is the matter relating to the alleged, or the case of murder of one Daniel Mudhiani, alias Sniper, and contributions towards his family, and the role, connection, or status of Kiambe Crispius Manyara, an accused person in that murder. The County Assembly, at volume number 2 of its documents, at page 429, has supplied this House with the charge sheet for that murder case. Distinguished senators, I beseech you to again make a principled decision in a matter such as this, where the County Assembly, by its own documents, admits that it's a matter pending active trial in our murder court, our high court. What is the policy of this Senate towards matters such as those? I submit that this is a matter of principle because this should be able to guide future impeachments so that we don't have to revisit these questions of principle. People can be guided by the decision of this Senate once and for all. Finally, the impeachment process itself in its entirety. I wish to refer you to volume number 2 of the governor's document at pages 28 to 32. At page 28, you can see Meru Constitutional Petition number E013 of 2024. The parties to that case are Honorable Kawira Mwangaza, petitioner, and the County Assembly of Meru, respondent. The two parties now appearing before you and represented by counsel, as has been the case. If we turn to page number 31 of the Governor's volume number 2, there is a ruling of court which says the upshot of the above is that the impeachment process is halted pending my ruling, and since this matter is of public interest, the ruling on the interested parties and the main petition will be delivered on 29th July 2024 via email to all parties. It is in the public domain that that ruling was not delivered on that day and is still pending delivery, and this order remains in force. As a matter of principle, I invite senators to reflect on this question, because the governor has been brought here by the county assembly claiming that it wants to strike a blow for the rule of law. And yet we are here debating this matter in the face of an order reading, and I quote, "The upshot of the above is that the impeachment process is halted." As a matter of principle, distinguished senators, what position do you want to take on this matter? You are the judges. You will make the decision one way or the other. I have done my part as legal representative to my clients. I have made full and candid disclosure that we may be perpetuating a violation of the rule of law. We may be. I am not the decision maker. I leave the eventual decision to your able hands, distinguished senators. Is this the way we shall grow our institutions? If a court of competent jurisdiction can make an order such as this, the county assembly proceeds in violation of this order. The governor has told you on her part, she has taken some action on this violation, and at page 35 onwards, you will see a contempt of court application that she has filed. She has done her part. The court will deal with that. Shall we, sitting here in good conscience and our attention having been drawn to these facts, perpetuate this process which on the face of it, the county government has undertaken in violation of a valid court order? It is not for the governor, it's not for her council to make that decision. Distinguished senators, the heavier task lies with you to make a decision one way or the other on these questions of principle, touching on those specific paragraphs of those specific counts that I have alluded to, and on this impeachment process as a whole, as I have drawn your attention to page 30 of volume number 2 of the governor's documents. Let me proceed by addressing you briefly on the Public Audit Act. Distinguished senators, I beseech you, as you make this decision this evening, to be guided by the provisions of Section 53 and Section 54 of the Public Audit Act. I say this in summary in response to the multiple audit questions that have arisen in the course of this hearing. Time will not permit me to point at specific audit queries. Having been present here, we know those audit questions. Section 53 of the Public Audit Act has a side note entitled Implementation of Reports. These are audit reports by an accounting officer. Implementation of reports by an accounting officer. Subsection 1 of Section 53 of the Public Audit Act provides, and I quote, the relevant accounting officer of a state organ or public entity shall within 3 months after Parliament has considered and made recommendations on the audit report. So first, there is an audit report. 2, there is parliamentary consideration of the audit report. Then 3, there are actions to be taken, which are take the relevant steps to implement the recommendations of Parliament on the report of the Auditor General, or give explanations in writing to Parliament on why the report has not been acted upon. The law itself actually anticipates failure to act on those reports with reason. Honorable Senators, there is a principle in law called the subsidiarity principle. The subsidiarity principle in law dictates that a dispute must be resolved at the lowest institution competent to resolve it. So, for example, as a litigation lawyer, if I have a case that can competently be handled by the High Court, but when I look at the law, it can also competently be handled by a lower court, a magistrate's court, I am obligated to file that case in the magistrate's court, which is the lowest court competent to hear that dispute. We now know that the County Assembly of Meru has not exercised its mandate by seizing these reports and making necessary recommendations or steps to be taken to implement the report. Instead, it has picked the reports and come to this house with those reports. I want to believe, speaking for myself, that that is overburdening this very busy house. I want to suggest to you, senators, that if you set a precedent here in these proceedings, that a county assembly can do that, it means that if we get a year where there are 47 county governments with some issues, and you know better than I do, that virtually every year, every county government has some issues in the audit report, it is possible for county assemblies to bring here 47 impeachment motions. I suspect that that may break the functional machinery of this house. I think that you better take a position in this matter that reminds county assemblies that they also have a role to discharge, to sit, invite relevant officers of the executive, interrogate audit reports, resolve disputes that can resolve there first, then come here with only such residues of issues that the relevant officers have proved to be incorrigible. That is my humble submission, distinguished senators. There is a cadre of claims before you where I submit respectfully that the county assembly is in fact the author of the problem. Then it has brought the governor here. The alleged failure to appoint chairpersons of the Meru County Revenue Board, Meru Microfinance Corporation, Meru Youth Service Board, and Meru County Investment and Development Board. I invite you to look at the correspondences at pages 53, 54, 57, 58, 60, 61, 62, 65, 67, 84, and the document at pages 85 all the way to 163, and the document at page 135 of volume 1B